going to speak for about 50 minutes. And then after that, we're going to have a questioning section, okay? And then we'll see how time goes then. All right? So please join me to welcome Professor Keith Hawkins.
Thanks very much. I hope you can hear me. I'm very pleased to be here. I've heard a lot about this law school in the course of my career, and it's really good finally to get here. All talk should start with a confession. Mine is that I'm so ancient that I don't know how to use PowerPoint. So if you'll forgive me, I'll just talk at you in the way that I do back home. I'm interested in how law works. There are various ways in which you can ask that question. The way I tend to ask it is to ask myself, under what conditions do legal rules apply? And under what conditions do legal actors find themselves making decisions on the basis of other forces to which they're subject? Moral, political, economic, interpersonal, organizational, and so on. As a result, I'm interested in the legal process and how law gets done. And how law gets done for me is a matter of studying the decisions that legal actors make. Because the legal process seems to me to be a matter of decision making by legal actors as well as members of the public in certain circumstances, but legal actors, people with legal authority, whether we're talking of judges or members of a parole board or a police officer on the street or an environmental inspector. For me, they're all legal actors. They all exercise a legal authority, and how they exercise that legal authority is what I'm really concerned with. I've been doing this sort of work all my career, really. I started life as a lawyer and moved on to do a PhD in criminology at a time when the then Royal Commission on the Penal System was considering introducing a parole system into England and Wales. This was in the mid-60s. And they realized that they knew nothing about the parole system. And my PhD supervisor, who was a member of the Royal Commission, suddenly realized he had a research student casting around for a topic to work on for his PhD dissertation, and suggested that I might like to look at the parole system. Well, there wasn't a parole system in operation in the UK, so I was packed off to the United States to spend a year sitting with parole boards, essentially observing, going with them to the prisons in the various states that I worked in, sitting with them and simply observing them interview prisoners and then reach a binary decision to release the prisoner on parole early from a sentence before the prisoner need legally be released, or to reject the prisoner's application, send him back for a further period. I say him because all of the prisoners I studied were males incarcerated in institutions for male prisoners. So I was studying the way in which a panel of decision makers made a simple binary in-out, release, reject decision. And from that, my work gradually developed into various other areas, governmental regulation being the most important of them, probably. Legal action, then, is a matter of decision-making. And decision-making, for me, is a matter of the interpretation of words, quite apart from what else it might be and what else it might involve. Legal actors have to make a decision about the problem they have encountered. They have to define it, and define it as potentially amenable to legal solution or not. And having defined it as such, they then have to decide whether to act. And having decided whether to act, they have to decide how to act. A number of sometimes quite complex decisions that are made very quickly, usually, in a very compressed way. But all of this suggests to me that law, whatever else it might be, is a human process. And it's a process that involves the exercise of discretion. I'm always a bit uneasy talking about discretion and using the word. I know for lawyers it's legally meaningful, but I much prefer to think in terms of legal decision-making. And the reason for that goes back to some research one of my American colleagues did many years ago, looking at the enforcement of housing codes in American cities. And one day he was riding around with a housing code inspector in the city of Buffalo when the inspector pulled the car up outside a house, rushed to the door, summoned the occupant to the door, and a rather worried lady appeared, and he said to her, "There's a freezer in your front yard, get rid of it. Do you know you're violating the Buffalo Housing Code, section 32C? The woman looked appropriately alarmed and said she was very sorry, officer. The inspector said that he would return at 3 o'clock that afternoon, and when he did, he wanted to see the freezer gone. He then drove off with my colleague and did some other routine inspections and returned at 3 o'clock in the afternoon, and there was the freezer gone. And he then turned to my colleague and said simply, "It always works. There is no section 32C of the Buffalo Housing Code. I made that up. Freezers are dangerous things if you leave them lying around in your front yard. A small child could open it, climb in, the door could close, and the child could die. But it always works." Is that discretion? There is no section 32C of the Buffalo Housing Code. For me, the raw material of that instance is interesting and important, although it may not have been a lawful exercise of discretion. I feel uneasy with the term unauthorized discretion as well, so I won't use it. But the behavior, the decision-making was interesting, intrinsically interesting, because here was a legal agent portraying himself as a legal agent and getting compliance with his particular demands. Lawyers use the concept of discretion, and from a lawyer's point of view, of course, it can be a useful concept. In the 50s and certainly most of the 60s, discretion was regarded in rather benevolent ways. It was something that mitigated the harshness of the application of legal rules. It was a way of individualizing justice in particularly difficult situations. It was basically regarded as a good thing. And then a number of people, different kinds of people, started questioning discretion. Some research was carried out. Some prisoners, especially those in California, started writing about the experience of being in prison and being the subject, or as they saw it, the victim of decisions made by the California Parole Board. And by the late 60s, discretion had suddenly become extremely suspect. People were very critical of it. By then, the federal courts and a number of legal academics, I'm thinking of people like Francis Allen, Sandy Kadish, and especially Kenneth Culp Davis, had begun writing scholarly critiques. And of course, the Warren Supreme Court was clarifying and extending the rights of individuals caught up in the arms of the law with the celebrated decisions that they handed down in the 60s, like Escobedo in Illinois, Miranda in Arizona, Memper and Ray, Gideon and Wainwright, and so on. The efforts of the academic lawyers and the impact of the Supreme Court together really made people to think critically about the nature of discretion. And some early research on the ways in which especially parole boards made their release decisions. Some of this early research was extremely critical of the lack of procedural due process, the sheer unpredictability, as they saw it, as those writing the critiques saw it, of being able to know what outcome was likely, all of which led to criticisms that the exercise of discretion in the criminal justice process was arbitrary and capricious. Those are the two adjectives that the critics like to use mostly. I shall argue shortly that the exercise of discretion is very often a very patterned, highly predictable, regular process. But let me just continue on this theme for the moment. Kenneth Davis, is the leading critic of discretion. He was invited by Louisiana State University to give a series of 8 public lectures in Baton Rouge in the late 60s, and his book, the culmination of this lecture series, was published first by Louisiana State University Press and then by the University of Illinois Press in 1969, and it's called Discretionary Justice. You may well know it. Extraordinarily, for a book of that vintage, it has never been out of print. And that shows something, I think, of its importance. Davis was extremely critical of discretion. He recognized that it was a bit like matter, that it couldn't be destroyed, but he was jolly well going to try to structure its use, limit its use, make its use much more accountable and reviewable and so on, much more transparent if possible. And he gave us a vocabulary of confining and structuring as a way of remedying the problems of discretionary behaviour as he saw them. Davis's work had a direct impact on criminal justice administration in the United States. It began with the Federal Parole Board, which was stung by his criticisms of its activities. His chapter on the Federal Parole Board is only about 8 pages long, but it's 8 pages of the most withering criticism. He ended by saying, on the whole, the performance of the Federal Parole Board is about the lowest I've ever seen in US government. And the board thought in order to survive, it ought to do something to improve the position. So it hired some criminologists who were experts in decision-making, who embarked on a fairly complex series of research projects to try to introduce ways in which the Federal Parole Board could ensure its survival by making sure that the discretion which it exercised was exercised in a much more regular and predictable and open fashion. And what these researchers did, these are people like Gottfredson and Wilkins and Peter Hoffman, what they actually came up with was parole guidelines. And from their work with parole guidelines, you see parole guidelines having been adopted by a large number of other states where they have retained their parole systems, and then guidelines spread to a considerable number of states for the use of sentences. So it's been a very important impact that Davis's critique of discretion has in fact been responsible for. Davis conceived of discretion as a lawyer would conceive of discretion. His remedies for the problems of discretion that he identified were the remedies that lawyers might prescribe. But I think Davis, frankly, misunderstands the nature of a lot of discretionary behaviour. I said, for example, that a lot of discretionary behaviour is actually rule-governed. The problem for people like Davis, the problem for lawyers, is that the rules that govern the exercise of discretion are not legal rules. They're processing rules or occupational rules or social interactional rules. There are all sorts of ways in which rules operate to make discretion patterned and regular. Just give you three kinds of instances, if I may. In the study I did of the regulation of occupational health and safety, I collected data and worked on this project for 18 years on and off. And in the course of that, I talked to a large number of people who worked in the bureaucracy, from the Director General, in whose office I hung around for several days, just observing what he did and talking to him when I could, and attending his meetings and listening to his phone calls and reading his files and so on, down to the most junior field inspector. And I remember very well talking to an area director about prosecution decision-making and the conditions under which he would wish his field inspectors to think about initiating a prosecution. And the man reeled off a set of general statements, the very predictable things. When there is a serious breach of the law, when someone's been badly injured, when there's a persistent unwillingness to comply with regulation, and so on. There were a number of these general conditions, which then culminated in the statement, and when someone has been struck by an overhead travelling crane. A statement of such precision and particularity that I was very surprised and said, why? And then there was silence. So I repeated my question, and again there was silence, and then rather hesitantly he said, because we always do. Whenever anyone is struck by an overhead travelling crane, we always prosecute. In other words, if condition A exists, then outcome B is decided upon. He had discretion as to whether to use the power to prosecute in such cases, and he had denied himself that discretion by the use of an organisationally derived rule. And sometimes people who exercise discretion prefer to deny themselves discretion. It makes life easier sometimes for them. Another aspect of this has to do with the kind of legal decisions that people make. Legal decisions involve all kinds of decision-making behaviour in all kinds of decision-making settings. Lawyers, I suppose, are most familiar with the idea of the judge hearing evidence and then retiring to reflect on the nature of the evidence in the process of coming to a verdict, an outcome. Sometimes this is a process that can take several hours, days, weeks, sometimes even longer. Contrast that with other legal decision makers who work in settings that require them to make decisions very quickly, repetitively, over and over again. I'm thinking of people like the people who have to sit in the glass booths in airport arrivals halls, checking passports to determine who is a fit person to be admitted to the country or not. That process has become mechanised a great deal now, so it's simplified. But some years ago, Janet Gilboy, who was working at the American Bar Foundation in Chicago at the time, sat with inspectors at O'Hare Airport when they were actually reading passports and making decisions on the basis of what they read in the passport. And she discovered that such was the need for these decisions to be made quickly, because there could be 1,500 hot, sweaty, irritable people in the arrivals hall at O'Hare Airport, all waiting to get through. And there are only 4 or 5 booths open. The inspectors are under considerable pressure to make decisions very quickly. She discovered that in 98% of cases, the matter was decided upon really very quickly by the application of some routine scrutiny of the passport. Only 2% were sent to one side to be scrutinised more closely. And frequently, legal decision makers find themselves in a position where they have to act now. And sometimes they act rather than think. I'm thinking of the police officer who's dealing with an unruly crowd, for example. The greatest virtue in police officers in that setting is to know how to, as they put it, handle a situation. They're not too worried about the niceties of the legal rules. They have to act and to decide how to act very quickly. A third aspect of this is that people who are engaged in routine or repetitive decision-making, making the same kinds of decisions about the same kinds of problem over and over again, routinely engage in stereotyping and typification. They classify the raw material for their decisions, whether it be a suspect on the police, on the street in an encounter with the police, or a factory inspector dealing with a recalcitrant employer who might be sailing a bit close to the wind of the health and safety legislation. Whatever it might be, there is a form of recipe knowledge, a set of typifications which come into play, which allows the decision maker to typify this person or this problem as a typical example of this kind of person or that kind of person. And once this kind of mental exercise is gone through, a decision is thereby prompted. The process of characterization means that once you have decided upon the nature of the problem or the nature of the person, then the recipe knowledge demands a precise and specific outcome. That, again, really denies discretion, because people are deciding formulaically. They're not stopping and reflecting, stopping and thinking. Very often they're in settings which don't allow them to stop and think. But discretion creates problems. As lawyers recognize, lawyers frequently respond, as Kenneth Davis responded, by saying rules can be, and in some cases must be, the answer. The problem is that rules create discretion. And problems arise from the use of a fixed verbal form. I want to mention a number of problems that I think are most apparent here. First is the sheer indeterminacy of language, which means that the meaning of rules may not be obvious. Rules are not necessarily transparent or self-evident. They need to be interpreted. Legal decision makers always engage in interpretation. The business of the law is the business of interpretation. What we produce in court, for example, as evidence, is really a product of the social reconstruction of reality. It's interpreted reality. And the problem with interpretation is its inherent ambiguity. You have to know setting and context and so on. The word or, one of the simplest and commonest words in the English language, means two completely opposite things, depending on its setting. It's conjunctive, joining two things together. So you're all sitting behind a desk or piece of furniture, where the or is joining the idea of desk and furniture because they're both bits of the same species of object. Or I could say to students in Oriel College at dinner, after you've had the main course, you may have cheese or fruit. The implication being that if you have cheese, you may not have fruit. If you have fruit, you may not have cheese. The or operating disjunctively. Of course, we know instinctively, usually, what the context tells us the meaning of the word is, but not always. And gestures are exactly the same. You know, if I do that, what does it mean? Well, in this particular context of someone sitting talking to you about an academic subject, it doesn't mean anything very much. For you, it may mean, can I ask a question? If I bike to college in the morning, I have to cross Oxford High Street. And sometimes a nice motorist will stop and let me cross in front of the car. So what do? I say thank you, and I do that. And if the motorist starts to move forward before I've crossed out of the way, I still do that. Because then it doesn't mean thanks, it means stop. Well, you get the point. All life is subject to interpretation and is inherently open to interpretive grabs, and that goes for legal rules as well. And of course, the facts upon which the rules are to be applied, or to which the rules might be deemed relevant. And then there's the problem of scope. The degree of discretion that's created. You may or may not get more or less discretion created if you use a simple rule. if you use a very complex rule, almost certainly you'll get more discretion. And I always recall Kenneth Davis saying somewhere in his writings how much he admired, as he put it, the 4,000 words of double-column fine print of the Internal Revenue Service Code, which he thought was ideal because there were so many rules there couldn't be any scope for the exercise of discretion by Internal Revenue Service inspectors. Well, a sociologist from Syracuse University by the name of Susan Long went along to Washington a few years after Davis wrote those words to see how the inspectors of the Internal Revenue Service actually coped. First thing she found was that they could only remember 7 or 8 rules, keep in their heads 7 or 8 rules at any one time. So they had to spend time poking through the 4,000 pages of double-column fine print that Davis so admired. And when they did that, sometimes they still couldn't find a rule that spoke to the particular problem that they were confronted with. So they had to fill in the gap. They exercised their discretion. They chose what to do. And in other cases, they found a rule on this page that said this when confronted with a particular problem, but on another page, another rule said that, something, as they used to say, completely different when addressing the same problem. So what they had to do then was to choose between competing rules which appeared to speak to the same problem. Again, they exercised their discretion. Another problem with rules is that they're imprecise. I'm thinking here about the problems of over-inclusive and under-inclusive rules, which are particularly apposite when you think about problems of environmental regulation. I remember the Director General of the Health and Safety Executive saying that there are something like 2,000 new chemicals devised for industrial use each year. And after use, these things have to be dumped into the environment or otherwise treated. And of course, people often don't know what impact they're going to have on land, air, or water. And the typical response of a regulatory agency like the Environment Agency is to write rules to target a family of chemicals which are thought potentially dangerous to the environment. If you write rules that are over-inclusive, you hit your target, and you'd hit other things as well. If you write under-inclusive rules, of course, you hit your target, but only part of your target. In the first case of the over-inclusive rules, you find that the environment benefits, but your industry is saddled with very substantial costs of compliance, which can lead to it being internationally uncompetitive, with the opposite effect, of course, with under-inclusive rules, where the environment suffers and industrialists benefit. So the problem of precision is a very important one and is usually cured by, again, the exercise of discretion. A fourth problem is that the clarity, certainty, stability, predictability, sense of continuity, and all the other virtues lawyers like to think of as important claims that can be made for rules can also lead to inflexibility. An excessive stability, a rigidity, if you like, that makes rule systems really unsuitable to cope with complexity and change, because the rules can't adapt quickly enough. Again, sometimes compelling the use of discretion. Another problem that arises is that rules are a bit like rabbits. They proliferate. At least in England, the tendency frequently seems to be that if a set of rules doesn't seem to be working terribly well, let's not sweep them away, let's try and make them better. It's the muddling through tendency of the English, I suspect. And so another set of rules is added to the existing set of rules to try to make things clearer, with the result that sometimes things get muddier, people get confused, and the position is not really improved. The final problem that I want to mention very quickly is the fact that rule makers have to anticipate implications and consequences, of course, and it's very difficult to predict the future. And the unanticipated consequence is a terrible problem so far as legal rules are concerned. Sometimes rules may be acted on, as the legislature might anticipate and expect. Sometimes they're acted on unpredictably, sometimes they're not acted on at all. I think of the experience we had in England with the introduction of the suspended sentence in the 1967 Criminal Justice Act. The suspended sentence was introduced in an effort to help limit the increase in the prison population level, which at the time of the legislation had reached the then intolerable level of about 36,000 people. There are currently about 87,000 people in our prisons. And Parliament decided that action had to be taken, and the suspended sentence was introduced as a way of stopping certain people who might otherwise go to prison from going to prison. At the same time, the parole system was introduced so that some people who had been sent to prison could be released earlier than the maximum sentence, so long as they were defined as suitable for early release by the parole board. The problem with the suspended sentence was that it was intended to work as an individual deterrent for a prisoner. In theory, the courts were to decide which people deserved to be sentenced to prison. And they were then to look at that group of people and decide which of the people sentenced to prison could have the actual execution of the sentence suspended. It was a way of, it was hoped, cutting off the bottom layer of imprisonable subjects. And the suspended sentence was intended to work as an individual deterrent, so that a person might be sentenced to a year's imprisonment, suspended for 2 years. The impact being that the person was free to live his or her life as they chose, but that if a further offence was committed during the period of suspension, they could be brought back before the court, convicted and penalised for the new offence, and the court would then have discretion as to whether to activate the suspended sentence wholly or in part, and discretion also to exercise, impose the term of actual imprisonment consecutively to any new sentence of imprisonment. And occasionally people did violate the law, were brought back before the court. The court saw that its generosity in the first instance had been abused, wanted to display to others who might be similarly tempted that Courts do not like seeing their generosity abused. They wanted to show people that the suspended sentence meant business and that you had to behave yourself. And so they were very tempted to activate the suspended sentence. And then when it came to the question of how much, the answer was usually in full. And then when it came to the question concurrently or consecutively, again, to make a point, it was almost always consecutively. So a person who might subsequently have been sentenced to 6 months imprisonment would then have the sentence, suspended sentence, activated and could find themselves doing 6 months plus another year for an offence that was only deemed worthy of 6 months imprisonment in the first instance. A colleague in Cambridge looked at the first 3 years of operation of the suspended sentence, and far from reducing the prison population as had been intended, the prison population, he calculated, had increased by about 3,000, by a substantial proportion. That seems to me to be a classic example of the unanticipated consequences arising from the use of rules without having thought through your institutional design really very thoroughly. It seems to me that whether we like it or not, we're going to have to learn to live with discretion because it's inevitable in legal systems. The facts that might be relevant to a legal problem, legal remedy, have to be interpreted, and they're not necessarily self-evident. The rules that may or may not apply have to be interpreted, and then an action has to be, or a decision has to be made about action, whether action is going to be taken, and if so, what action is going to be taken. And of course, another problem is that discretion is increasingly central in modern legal systems. They increasingly rely upon the work of legal bureaucracies, to which are transferred large areas of legislative authority to be responsible for the design, maintenance, construction, operation, and so on of nuclear power plants, for example. Let me finish by trying to give you a flavour of some of the other forces that seem to me to shape the decisions that people make, and I'll be very brief here. One is the moral code that people live by. We all live by a moral code to a greater or lesser extent, and what frequently is taken to indicate compliance with a legal provision is really compliance with a moral provision. People don't take things belonging to others because there is a criminal law prohibiting that. Most people don't take things that don't belong to them because they're complying with their moral code that tells them that you don't take things that belong to other people. That's something they've been socialized in from early years. And moral matters are frequently the reason for, in the criminal law, the invocation of the criminal law. Many frontline law enforcers decide to make a case of a particular matter, to bring someone in and deal with them as a potential prosecution, not because there is a breach of the law, but because they jolly well think this person did something bad and wrong and deserves to have this response. Cultural influences are also very important in terms of law use and the willingness to use law, particularly in private matters. The Americans are widely believed to be willing to sue on every conceivable occasion, and sometimes on inconceivable occasions as well. Actually, that is a bit overdone. There's a wonderful essay by David Engel in the Law and Society Review called The Ovenbird Song, which is one of the classics of the socio-legal literature, in my opinion, in which he shows that so far as rural Americans are concerned, they're willing to act when they think there might be a breach of contract affecting them, but if they're the victim of an accident, well, it happens. It's fate. You lump it. You don't think about consulting the nearest lawyer. It may be that the cultural impressions we have of American litigiousness describe more accurately the behaviour of urban Americans living in large urban centres, living in a population of strangers. Institutional arrangements are terribly important. Rules about fees and rules about costs, for example, and who carries what, and how do you pay and who pays. Political forces are an important feature in the environment of some decision makers. The work I did with the Health and Safety Executive suggested that their field inspectors are very sensitive to the general political climate, and when it comes to using their power to prosecute, if it's a right-of-centre Conservative administration, they might be a little more conscious of the need to be sensitive to the fact that such governments tend to be less sympathetic to seeing business and productive industry, as they see it, dragged into the courts to be prosecuted by a publicly funded, bloated bureaucracy, as some of them see it. And the same goes for the economic context in which these sorts of legal actors find themselves working. In a time of recession, the health and safety inspectors told me they were more sensitive to the fact that by prosecuting a business or a firm, especially one that was struggling, they might make things worse. People might actually be laid off as a consequence of some penalty, a financial penalty that the firm would have to come up with if it were convicted of an offence. Then a couple of other features. Organisational features are very important, and lots of law these days is done by organisations. And organisations like to behave very much like human beings. They like to be well thought of. They like to advertise their presence and what good things they do. And sometimes you find organisations will use the public arena of the courtroom and the public measure of prosecution as a way of making a statement about things they disapprove of, and conversely, by not prosecuting, things that they are prepared to condone. And individuals within an organisation operate in the same way. Field inspectors like to present themselves in a good light so far as their supervising inspectors and their area directors are concerned, because they depend upon them for promotion and advancement. And I well remember another area director I talked to at length about prosecution who told me that so far as his construction inspectors were concerned, he wanted to see them in court about a dozen times a year. Construction is a very dangerous occupation. People fall off scaffolding and fall through roofs, and trenches collapse on them, and there are a number of deaths each year on building sites. So he wanted his inspectors to be in court prosecuting cases about once a month on average. I then went and talked to his inspectors and asked about this and gave them a couple of hypothetical examples. And I said, suppose that you're 3/4 of the way through your year and you've already got a dozen prosecutions under your belt. What do you do? And the answer, without exception, was, I'll go easy. I don't want to have too many prosecutions. I don't want to get too much beyond my quota, because my area director will think I don't use my judgment wisely. I'm a bit of a bull in a china shop. So I need to give him the right impression that I make sensible decisions. And of course, the obvious follow-up question is, what happens if you're 3/4 of the way through the year and you've only had a couple of prosecutions? What do you do? And the answer, predictably, was, I'll go out and look for some cases. I'll go out and look for cases to prosecute that I wouldn't normally prosecute. Because I need to show my area director that I don't sit around. I get on with things and I do my job. I need to show that I'm actively out there engaged in making the workplace healthier and safer. So I'll look for more cases. Now, that sort of decision-making is determined not by any legal merits there may be in a particular matter, is determined solely by the legal actor's membership of an organization. It's the organizational constraints that are leading to the discretion being used in that particular way. A couple of final points. I've talked about decision-making as if it's an individualistic exercise. It's hardly ever, if ever, an individualistic exercise. Even if individuals have legally the power to make a decision, almost certainly they do so on the basis of information that they've been supplied with, or other material which others have provided for them. But, of course, other kinds of legal decisions are group decisions. The decisions of juries, of appeal courts, of Supreme Courts. And with such group decisions, the parole board is another good example, there is always pressure upon, certainly so far as the parole board's concerned, and certainly so far as juries are concerned, there's pressure upon the members to come to a unanimous outcome. How is that resolved? It's resolved by negotiation. It's resolved by bargaining, in which people compete using various sources of power they have in interaction, like status, expertise, charisma, and so on, to persuade their colleagues of the strength of their position. And sometimes you see people explicitly bargaining with colleagues saying how I agreed with you an hour ago when you had that case that I was a bit reluctant to release, but nonetheless I went along with you. Now I've got this case that I want to see released and you don't. Will you go along with me? It may not be put in words as explicitly as that, but the message, the bargaining is clear. Now, just a final comment. It seems to me that the way of the law is really negotiation. That's the way things are done in the legal system. We as lawyers think of adjudication, of trial, of judges as the key thing. But courts are terribly unimportant places. At the same time, courts are terribly important places. They're unimportant quantitatively because so few matters ever get to court. Only 2 to 3% of all offences known to the police in England and Wales result in the conviction of an offender, for example. And the proportion of personal injury actions that see the inside of a courtroom is rather smaller than that. But of course, and especially in a common law jurisdiction, qualitatively, courts are very important places for the legal authority that they exercise and for their capacity to provide clear and decisive outcomes. My point is that sociolegal scholars really need to poke around in the messy reality of everyday law use and law decision-making to see how the legal rules play in all of this, how people negotiate. The legal rules are terribly important in many forms of negotiation, of course, because they are the major marker of the strength of a particular party's position in any negotiation. But it's also the case that legal rules are avoided or ignored or unknown, and sometimes they're subverted. I can give you an illustration of that at question time if you like, but I'm sure I've talked for quite long enough, so I ought to pause there.
Okay, would anyone like to raise any question or any issue? Yes.
I'm from the philosophy department from CUH at the Chinese University of Hong Kong. So my question would be from a philosophy background. I wonder what you think about this. You were from a sociology background way back when, but for philosophy it may be more theoretical. But when we make decisions, we make it in a context, given limited information about the world. But then there may be an objective reality to morality. There are no answers to all moral questions. Maybe if there is, then maybe the law try to approach that objectivity. That's what I think as a citizen. But for rules, maybe because we make decisions in context, sometimes the rules do not generalize over all situations, such that the rules, they are the legislator's attempt to lay down what are moral truths. That's what I think. But that's a limited way to do so because of this limitation of us making decisions in context. So that's an inherent defect of the way we go with rules. And I understand you in that discretions are allowing the way for individual legal actors to exercise their conscience, maybe. And but somehow you talked about how economic or organizational factors may affect the decision making as well, the bargaining and negotiation you talked about. So I wonder, given your outlook of depending on how legal actors make decisions, what do you think of the objectivity of morality or even legal?
I have a problem with the whole idea that there is such a thing as an objective morality, because I'm much more interested in morality as people understand it and experience it and interpret it, than to see what impact that has upon some choice that they end up making. So I probably work in a very different world from the one that you do, because I just have difficulty with that kind of concept, I'm afraid.
So does that commit you to something like relativism? If
something like
relativism.
Yes.
So morality is relative to people's decision.
Yeah.
And so maybe in a legal system or maybe in a society with certain laws, what they do is right because the legal institution decided it to be so. Is that?
Well, just thinking of something you said in your earlier comment, and you talked about law as an embodiment of morality. That is only true up to a point. I think my colleague Andrew Ashworth did a study of the substance of English criminal law and found that the majority of legal offences in English law are actually strict liability offences, suggesting that there is no concern, so far as the legislature is concerned, with any kind of moral element. All it's concerned with is the pragmatic need to get things done, get certain things enforced in the interests of the advancement of social order, for example. I realise that this is not at all consonant with the kind of language, way of thinking that you're familiar with. But my starting point is behaviour, and what happens, and why does it happen in this way? And I try to start with as few preconceptions as possible. So morality is a feature in the decisions that are arrived at by individual legal actors. The police officer dealing with a suspect on the street, for example, may decide not to take the suspect down to the station for further questioning, may decide to turn a blind eye because she doesn't deserve it. You know, what she did, it was accidental. She didn't realise she was breaking the law. Whatever the reason is, there'll be all sorts of reasons given, but frequently rationalised in terms of desert, which of course is a moral concept. And that's essentially where I start.
Short follow-up. In fact, even if you're following the interest of the society, that's still morality, I think. Our view may not be that inconsistent, although your approach will be more pragmatic and see how people make decisions, and I see your point.
Yes, and of course the morality operates at two levels. I mean, this all operates at two levels. There's a legislative rulemaking level where all of these values may intrude, and where the rules may be an expression of morality. But the individual level, you often find these things playing out in a very similar way.
Okay, anyone else? Yep.
Thanks for coming tonight, Professor Hawkins, all the way from Royal College. I will have two questions to ask. First, it's basically a matter of personal opinion, but do you think first the prosecution, like in Hong Kong's Department of Justice, should be given wide discretion on whether and when to prosecute any cases, and under what circumstances do you think they should? Do you think they should have clear guidelines as to under certain circumstances they should and must prosecute, or at least give the public an explanation as to why they make the prosecutorial decision?
Yeah, I'll speak in total ignorance of anything to do with the legal system or legal processes in Hong Kong. So please bear with me. The other thing to say is that your questions are policy questions, and one of the things I have tried to do in my research is not to encumber myself with policy concerns, because I didn't want policy concerns in some way to frame the way I just designed the research or interpreted the findings and so on. But to try to answer your questions, I suppose it's a question of what you want to do with the prosecution process, or whatever process we're talking about in the criminal justice system. Having made claims that discretion is patterned and predictable and regular in some respects, the regularities are frequently regularities to be observed within individual decision makers. But you find that although individual decision makers are true to themselves, when you compare the way they decide with the way their colleagues, their fellows, making similar kinds of decisions, you find there's disparity. This was brought home to me very clearly in my PhD research, where I collected a lot of data, observational data on release decision making in the New York and California parole boards, and gave the New York board members a decision schedule, a very detailed decision schedule to fill out after completing hearings on a stratified sample of prisoners. And there were 11 commissioners of parole in New York at the time I did the research, and 5 of the 11 board members were releasing about 55% of all prisoners that they encountered at their first hearings. The other 6 board members dealing with a comparable sample of prisoners would only release about 30%. In other words, there was a very good chance that the decision whether you were released or not didn't depend upon the merits of the case you brought before them, but upon the actual decision maker you appeared before. Now, as a personal matter, that seems to me to be an unjustifiable disparity. This is where I'm thinking about the sort of values you want to advance, preserve, protect in prosecution decision-making. If you are concerned with a measure of rational consistency among your decision-makers, then it seems to me some sort of guidelines are extremely valuable. The problem is how to formulate guidelines that will actually constrain discretion. I don't know of attempts to guide prosecutorial discretion. There have been lots of efforts to constrain sentencing discretion, especially in the United States. In England, judges like to claim there are sentencing guidelines, but they're sentencing guidelines of a verbal sort. In other words, we write out what the guidelines are. And I've already talked about the ambiguity of words and how things have to be interpreted, and then add that to the fact that English lawyers are brought up in English law, in the adversarial system of English law, and their skills are in exploring and exploiting the ambiguity of words. So judges can make words mean what they want them to mean. The case of Cunningham in the Court of Appeal in, I think it was 1992, which was a test of the sentencing provisions of the 1991 Criminal Justice Act, which stated very clearly that sentencing was a matter of awarding offenders their just deserts, and if a person appeared to the sentencer to pose a threat to the safety of the community, an additional sentence of imprisonment could be added. So it was essentially a just deserts form of sentencing. It was a quantitative retributionist approach with a little bit of exclusion added on for a defined category of offenders. That was all. It went before, a case went before the Court of Appeal on appeal, and the Lord Chief Justice handed down a decision which boldly declared that sentencing was a matter of awarding people their just deserts and excluding them on public safety grounds, but also sentencing was a matter of rehabilitation of the offender and deterrence of the offender or of others who might be similarly tempted. I can't remember whether those words actually appear anywhere in the Criminal Justice Act 1991, but here you have a senior lawyer willing to how shall we say, be flexible in interpreting the meaning of words. So the form any guidelines might take is absolutely crucial. Guidelines probably work best when, like the American sentencing guidelines, they are based on empirical research about offender risk and systematic research about people's assessments of the gravity of or triviality of offences, and then a matrix is developed from that. The problem with that is, as I discovered when talking to judges in England, people don't like numbers being used to dispose of cases. That's putting it crudely, but that's how they see it. They're happier having words disposing of people, because words can mean, as Alice in Wonderland once said, what we choose them to mean. So verbal guidelines probably won't work. The things that might work could be some kind of quantitative-based decision-making. Don't know quite how you'd apply that to the prosecution arena.
Because in Hong Kong, we
The problem with sentencing discretion is knowing where to strike the balance. In the United States, in the mid-70s, there's a bit of a frenzy of eliminating judicial discretion to the greatest possible extent. In California, they passed the Determinate Sentencing Act of 1976, which specified that if you were convicted of the felony of burglary, you shall be sentenced mandatorily, no discretion, to 3 years imprisonment in the custody of the Department of Corrections. If the prosecution could plead and prove it was an aggravated offence, it was 4 years, and if the defence could plead and prove it was a mitigated offence, it was a first offender or no damage was done and little property was involved, it was only 2 years. And of course, since then, we've seen efforts to eliminate discretion with the use of three strikes legislation. I don't know if people here are familiar with the notorious case of Jerry Williams. Does that mean anything to anyone? Jerry Williams fell foul of the California three strikes law, which says that a person convicted in the state of California for their third felony shall be sentenced to 25 to life. And Jerry Williams, I'm afraid, stole a slice of pizza several years ago. And unfortunately, it was discovered that he already had 2 felony convictions. So they prosecuted him for the felony of theft. And he went down for 25 to life, and he's still there. Eliminating judicial discretion can lead to all kinds of injustice. But it seems to me that you can get injustice also from highly disparate outcomes that judges are capable of making, and you can have appeal mechanisms and they work up to a point. You can have verbal guidelines mechanisms. I don't know how well they work, frankly. Perhaps they need to be drawn a bit more tightly if you want to achieve real guidance without at the same time shackling the judges, so that you create another kind of disparity by treating unlike people in like ways, which is the invisible sort of disparity.
Any other? Yeah.
How many cases does this board deal with in a year? I ask because if they have lots and lots of decisions of a similar sort to make, they may well find they don't have the resources to do very much by way of giving reasons. The problem with giving reasons, this is one of the inherent difficulties in trying to research something as elusive as decision-making, is that we can't get inside people's heads. We can't know how decisions are actually made by legal decision-makers. We can only know a decision by its outcome. I served a couple of terms on the parole board for England and Wales, so I've been fortunate in having an insider's perspective and in knowing how I read a case file and how I came to a decision that this case could be released, but that case, for various reasons, was not appropriate for release at the time. For a researcher, it's virtually impossible to know in any particular case how and why a decision maker acted. Simply because I can say to you, I decided to do this for this reason, when in fact I decided to do this for a completely different reason. That allows police officers, for example, to express all sorts of personal biases, perhaps about racial or ethnic minorities in such a way as to allow them to clothe their prejudices in legally acceptable terminology. I don't know if you're familiar with the work done on policing in Britain with the use of presentational rules. If there's a prohibitory rule which says you must not discriminate against people on the basis of race, colour, gender, age, and so on, police officers occupationally will do that, because one of the occupational rules in the police force is with certain kinds of people you've got to show them that you're the boss. So you go around and hassle them a bit. And if you are asked to justify why you stopped and searched this person, when the reality was they were a type of person that you personally don't particularly approve of, and you wanted to show them that you're boss. It's young urban males on street corners, that sort of thing. You go along to your station sergeant and you say, I had reason to believe they were going equipped to commit burglary. You're using a proper legal rule to present as the reason for acting improperly, illegally. So the problem is that people can say one thing having done another. And it's attractive from a legal process point of view, a due process point of view, to expect legal decision makers to articulate the reasons why they entered a particular decision, but you've got to trust them that they're being honest. And some are, no doubt, but some aren't. We're all people with all of our human frailties, and I don't know of any way in which we can police that. The other point about giving reasons is that the reasons have to be workable, serviceable, useful. The California Parole Board used to go to leave reasons for its decisions in every case because they were required to on the prisoner's record each time they'd finished the hearing, and what they wrote was time served. That was all. That was the reason. That was all they had to do. What does that mean? The prisoner has served enough time for his crime, therefore may be released. The prisoner has not served enough time for his crime, therefore may not be released. Time served serves perfectly well as a rationale for both forms of decision. So personally, I wouldn't be optimistic about any kind of real constraint or guidance or transparency being created by a requirement that decision makers give reasons for a decision they've reached.
I think I've got to exercise my discretion to end this because our booking is for until 8. Anyway, so thank you very much, Professor, for this fascinating talk. And I believe we've now got an announcement. Is it by, is it Cindy or did you? Yep. Do you want to, yeah?
was your son-in-law student in Royal College back in 5 or 6 years in the past, and I've got you.
I hope you enjoyed the experience.
I've got a photo I've taken with you because you mentioned it's me back, and I think it's you
Right.
5 to 6 years.
My goodness me.
And I think it's you.
It is me, yes.
Yes,
I'm
it's
sorry
me.
to say it's me, yes.
It was like 5 to 6 years ago when I was not even a law student in a summer law school program.
My goodness, don't I look fierce?
And I'm now going to be Pupil Barrister soon.
Oh, good.
And yeah, it's great to meet you.
Well, I'm pleased to see you again. I hope